The JMF Advisors Show is a podcast for business owners, C-suite executives, and entrepreneurs who are looking to build, grow, or even exit a business.
We bring in some of our best financial advisors to interview experts on business best practices, hot topics, and sprinkle in some tax and accounting help.
If you're a business owner, startup founder, CFO, or just starting your side hustle, this podcast is for you.
Hello, welcome to the JMF Advisor Show. I am Orman Wilson. I'm a tax manager with JamisonMoneyFarmer, and my co-host today is Emilee Scheef, who is an attorney with Rosen, Harwood, and we want to talk about family legacy planning. And before we get started, I think it's important that I mention the Tax Cuts and Jobs Act of 2017. This seemed to have given some false indication to people that, hey, with the estate exemption being raised so high, I no longer need to do any estate planning. And while the exemption did double, in fact, this year it's $13.61 million per person. You still need a will to direct where you want your assets to go. And also keep in mind, this act is going to sunset December 31st of 2025. And what does that mean? It means the estate exemption is going to be lowered back to the $5 million that it was before it was passed. Experts think that with inflation indexing, you're probably going to be looking at maybe $7.5 million. And I know what you're thinking. Well, that covers me. I'm not going to go, I won't owe estate taxes, so I don't need to do any planning. Emilee is here to tell you why you do need to plan, because even if you don't have a taxable estate, you don't want the state deciding who gets your assets. You don't want your wife and kids fighting over who gets what. So, Emilee.
Yes.
If you die without a will, that's a bad thing.
It's an expensive thing.
Yes.
Essentially, the state of Alabama, or whatever state you may live in, has a plan for you. You just may not know it.
And may not like it.
And you definitely may not like it. You could end up in a situation if one spouse passes away where you're owning your house or any other property with your kids or with your in-laws, instead of just the surviving spouse receiving everything, which is a huge reason to do your own planning so that you can pick where your stuff goes. And also to make sure that somebody who doesn't need to receive assets doesn't actually inherit anything. You know, if somebody were to have a problem or be a minor, that's a very good reason to make sure you do a plan where stuff is held for them in trust or something like that, so that they don't receive those assets outright.
Yeah. I know my wife and I have what is referred to as sweetheart wills.
Yes.
Where if I go first, she gets what little I have, and vice versa. And then the second one to die, the children get it. That's not as common as it used to be, because in this day and time, you have a lot of blended families where maybe it's a second wife and you may have children by the first marriage. And so you want to make sure that your assets go where you want them to go. So how would that work?
A lot of times there's a trust involved in that situation. So when the first spouse passes away, the assets would go into trust for the surviving spouse, so that they would then, at the second spouse's passing, go on down to the children. If you did not do the trust, then that spouse could give it to their new husband or their children from a previous marriage, and you could end up with, I call it an accidental disinheritance if they leave it to the new spouse, or you can end up with that spouse leaving it all to their kids and cutting yours out completely. If it's in trust, they don't have an option to cut out your children. You've set that up and locked that in.
Okay. Yeah, and I know there are times when, for various reasons, you wouldn't want your children to get it, and that's why you would set it in trust. But that's another podcast in itself.
We could spend many hours on that.
Yes. So, okay. The wills, I think we've taken care of that. What about healthcare directives? I know everybody is familiar with the DNR, do not resuscitate, but basically that's just something on file with the hospital.
Typically, yes. That is when a lot of times someone has had a lot of previous medical issues that have resulted in them being in the hospital and being resuscitated or something, and the hospital will ask you, do you want to continue that process? And so you would sign something that they keep on file. It's also important to have a healthcare power of attorney or advance directive so that if you're just incapacitated and it's not a coded situation, that there is someone there that can speak for you and make sure that your wishes are carried out. I kind of separate my documents into a healthcare power of attorney, which covers non-terminal healthcare decisions. So as people get older, who's going to the doctor with you? If you're not able to understand something, who's the doctor taking direction from? If I'm in a car accident, for example, and I'm incapacitated and the doctor has to come out and talk to somebody about the pros and cons of a procedure, who are they talking to and taking direction from? You want to pick that person. You don't want to kind of leave that to chance. And especially if you've got multiple kids, you don't want them up there fighting over who's making the decision. And also, the other document is an advance directive or living will, which you make your decisions that you would want in a terminal situation, and you put somebody to be what I call the enforcer of those wishes. So our legislature's kind of laid out a general form that everybody pretty much uses that covers two medical scenarios: permanent incapacity, so essentially two doctors have certified that you don't have any brain activity, and terminal illness or injury. And again, two doctors have determined that it is a terminal condition that's not going to get any better. And in those scenarios, you get to make your wishes known as to what you would want. So do you want to be kept on life-sustaining treatment like a ventilator, if that's the only thing prolonging what's going to happen? Or do you want artificially provided food and hydration through a tube or IV? Do you want a feeding tube, essentially, if that's the only thing prolonging the inevitable, as I say? A lot of times people have kind of started to forget the Terry Schiavo situation. She did not have these documents, and her husband thought she wanted one thing and kept saying that she did not want to be kept on a feeding tube if that was the only thing prolonging. And her parents were saying she did, and they went back and forth in the courts for, I think it was at least a couple of years. And she would get plugged up, unplugged, and hers was a feeding tube, like I said, so it wasn't an instantaneous passing. But it went back and forth for years, and that could have all been avoided if the judge had known what she wanted for sure. And in that scenario, if she had just done a living will, advance directive, everybody would have known her wishes. And she would have also picked who's in charge of making sure the doctors and the hospitals know what she wants. I mean, if I'm that sick, I'm probably not grabbing paperwork on the way out the door of the hospital and handing it to the doctor. So somebody's got to go grab my documents and make sure that the doctors know this is what Emilee wanted in that situation.
Yeah.
And if you've got multiple children or spouse and children, you want to make sure that they kind of have an order, because again, your kids may not agree. And another thing that's important is you want to talk to them about those decisions beforehand.
Yeah, so this is something you plan in advance.
Yes.
It's not a last minute.
Right. you don't want to be making those decisions if you're that sick and this is something that's coming. You know, it's a lot easier to talk. I mean, it's not easy to talk about in general, but it's a lot easier to talk about it when it's something way out in the future.
Yeah.
And it's really important also that you have those conversations with your spouse and your children. Because if they are under the stress of mom or dad being that sick and potentially dying, it is very comforting to them if they already knew what you wanted.
Yeah.
That they're not guessing as to what mom or dad wanted, and that this is something that they have already had the conversation. They know what mom and dad wanted, and there's a little bit of, I think, peace that comes with knowing that.
Yeah. Now, I know HIPAA is a huge thing in the world today. So how do these advanced directives sort of interact with the HIPAA authorizations?
So the HIPAA authorizations, you sign one probably every time you go to your doctor's office, but you may not list more than just your spouse. So typically, as part of an estate planning package, you will get a HIPAA authorization that covers all the people you appoint, because healthcare providers get in a lot of trouble for releasing your healthcare information, a lot more so than your financial, believe it or not. But if you have appointed a child or something in the enforcer role, as I call it, and they're not on that doctor's HIPAA authorization, the doctor can't give them all of the background healthcare information. So it's very important that you list them all in an additional document, because you want them to have the full picture and not just making the decision in a tiny vacuum.
So if I'm supposed to be the enforcer and I'm not on this HIPAA blanket authorization, I won't have all the information I need to make my decision.
The doctors could have a very hard time telling you the past medical history.
Okay.
They can explain to you the current situation, but if there's a long past medical history that is important, they're technically not supposed to release that.
Okay. All right. And finally, today we want to talk about powers of attorney.
Yes.
We want to talk about financial powers of attorney, how they compare to a conservatorship as far as fees, expenses, and that type thing.
Well, this is another one that doing a financial power of attorney is a lot less expensive than having to go through the court conservatorship process to put somebody in charge of your assets. If you're not able to pay the bills, who's that going to be? Who's going to be the one that steps in and makes sure that the mortgage gets paid and the power bill gets paid? If you don't appoint somebody, then they have to go ask the judge for who that's going to be. And you also have to go through and account for every single dollar that is spent to the court. You also have to have a bond that covers all of your assets. So it gets very expensive very quickly.
And the bond is based on the asset value?
Correct. The asset value and also the amount of income that you have coming in on a yearly basis. So there's a calculation that happens, and then you have to purchase a bond, which is essentially an insurance policy that you aren't going to steal the money, and pay that, and you can get into the thousands of dollars fairly quickly with a house and a couple retirement accounts and your bank accounts. And a financial power of attorney could avoid that. You pick who's going to be in charge of handling that, and they don't have to have a bond, and they're able to do all of these things without the court involvement. So it's faster. So if they need to sell an asset, they can do that without substantial delay.
All right. Now, I can become physically unable to write a check or work online and pay bills. All right. What about a mental? I need a letter of incapacity or whatever if I actually start losing
So
mental
you
faculties?
have the option for when your financial power of attorney is going to be effective. So there's two options. The first is it can become effective immediately when you sign that document. So if you are just physically unable to go and do the things that you needed to do to handle your finances, you can make it effective immediately, and you're working with your agent to ensure that all of the bills are paid. The other option is making it effective only upon your incapacity. In that situation, your appointed individual would have to have the power of attorney and a letter from the doctor stating that you're unable to handle your financial affairs. That is when it's typically a mental incapacity that comes into play. And in that scenario, they have to have both documents to be able to act. So it's a little bit more of a hurdle, but you stay fully in control until that time comes.
Okay.
So.
All right. I know we have talked a lot. We have covered a lot. And I'm sure people will probably have questions. They can feel free to contact me or contact you, and we will try to answer any questions they have. Be sure to like or follow this podcast, subscribe, and until next time, thank you so much.
If you would like us to help your business or would like to suggest additional podcast topics, simply send an email to info@jmf.com.
And don't forget to subscribe to our podcast on YouTube and your favorite audio podcast apps.